Good afternoon, everyone. We'll be getting started here in just a few minutes. Hope everybody's having a good day. We are so happy to have you here. Give everybody just a few minutes to join. Okay, we will go ahead and get started. Like I said, welcome to everyone for being here today. This is our first webinar of the 23-24 school year for our family webinar series about really empowering families to be able to support their children and to add to your toolbox as you are going through the special education process. My name is Sarah Untersee. I am the School Family and Community Engagement Consultant here at Region 10 ESC. We also have Jim Wright with us from Partners Resource Network, and so I'll let him introduce himself and talk just a little bit about Partners Resource Network before we start.
Thank you, Sarah. It's amazing that we have another school year to get going here, and it's going. I'm Jim Wright. I'm with Partners Resource Network. We're Texas State PTI, Parent Training and Information Center. We have 4 projects across the state. Region 10 is in the PACT project. I'm the regional coordinator for Region 10. All of our services are free. We are funded by the Department of Education to help families with disabilities from children ages 0 to 26. Thank you for having us, Sarah.
Thank you. So today's webinar is Know Your Rights, and it is a brief overview of the procedural safeguards. That is a really long document, and it is sometimes a little bit hard to get through, a little dry. So we're going to try to break that down a little bit so that you have just kind of a brief overview of what's included into that document. You'll notice as we go through the slides, page numbers are also there. So if there is an area that's something that is really relevant to you as a family member of a child with a disability, you'll know where in that document to go and look to get a little bit more information. So Jim's going to drop the link to this presentation into the chat. I will also email this out following today's webinar. Our webinar today is being recorded, and this will be posted on the Region 10 website once it is made accessible. So you will have the opportunity to go back and view this again if you would like to. What is the Notice of Procedural Safeguards? The Notice of Procedural Safeguards explains parents' rights and responsibilities under the Individuals with Disabilities Education Act, or IDEA. Today's webinar will provide a brief overview of each section of the procedural safeguards. You can view the full version of the document at spedtext.org. That is available in over 20 languages on that website. When should I receive a copy of the procedural safeguards? It may feel like you're being given procedural safeguards all the time from your child's school, but IDEA does require that school districts and charter schools provide the procedural safeguards to parents at least once a year and on the following occasions. So upon initial referral or your request for evaluation, on the first occurrence of filing a due process hearing complaint or special education complaint during a school year, when there is a disciplinary change of placement for a student, or just when there is a request by a parent for a copy of those procedural safeguards. Language requirements. Schools must provide a copy of the parent's native language or other mode of communication unless it is clearly not feasible to do so. SpedText has translated the procedural safeguards and the ARD guide into over 24 languages, and both documents are available on the SpedText website. Okay, at the beginning of the procedural safeguards on page 1, it does talk about foster parents. A foster parent for a child with a disability may serve as the parent if they agree to participate in making special education decisions. Complete the required training before the child's next ARD meeting, but not later than 90 days after they begin acting as the parent. For surrogate parents, this is also on page 1. If, after reasonable efforts, the school cannot identify or find the parent of the child, or the foster parent is unwilling or unable to serve as the parent, or if the child does not reside in a foster home setting, or the child is a ward of the state or an unaccompanied homeless youth, the school must appoint a surrogate parent to act in place of the child's parent, unless the child is a ward of the court and the court has appointed a surrogate parent. Surrogate parents must complete the required training before the child's next ARD meeting, but not later than 90 days after the initial appointment as a surrogate parent. Page 2 is about child find. And child find means that all children with disabilities that are living in the state who need special education services must be located, identified, and evaluated. This includes children with disabilities who attend private schools or who are homeschooled. Prior written notice. The public school must provide you with certain written information, and this is called prior written notice. Prior written notice must be provided by the school before it proposes or refuses to start or change the identification, evaluation, educational placement, or special education services that are provided to a child. The school must provide prior written notice, even if you agreed to the change or if you requested the change. The school must give you prior written notice at least 5 school days before it proposes or refuses the action, unless you agree to a shorter time frame. Parental consent. This is on page 3. Informed consent means that you have been given all of the information that's related to what the school is asking permission to do. Consent is always voluntary, and so granting of your consent means that you can revoke it at any time, but it must be done in writing, and revoking consent is not retroactive. Parental consent is required before conducting an initial evaluation for special education. To provide special education services for a child for the first time, to reevaluate a child unless the school can demonstrate that it took reasonable measures to obtain your consent and you failed to respond. An independent education evaluation, or IEE. If you disagree with an evaluation provided by your child's school, you have the right to request that your child be evaluated at the school district's expense by someone who does not work for the school. When you ask for an IEE, the school must give you information about its evaluation criteria and where to get an IEE. Discipline procedures. This goes from pages 5 through 8 of the procedural safeguards. If your child violates the school's code of conduct, the school must follow certain procedures if it removes your child from their current placement, and that removal constitutes a change of placement. So up to 10 days, your child can be suspended for up to 10 days in a school year without creating a change of placement. but for more than 10 days. If your child is suspended for longer than that, then a change of placement has occurred. And if that were to happen, then an admission review, dismissal, or ARD meeting must be held to conduct what is called a manifestation determination review, or an MDR. A manifestation determination ARD committee will review all of the relevant information, determine if the misconduct is a manifestation of the child's disability, or if it's the result of the school not implementing the student's individualized education program, or IEP. Is the misconduct a manifestation of the child's disability? Yes. If no behavior intervention plan, or BIP, then the school is going to conduct what's called a functional behavior assessment, or FBA, and then it will implement a BIP. If there is already a BIP, the school is likely going to be reviewing and modifying the BIP. If no, and the ARD committee determines that the misconduct is not a manifestation of the child's disability, then your child can be disciplined in the same manner and for the same duration as non-disabled children. Your child must continue to receive a free appropriate public education, or FAPE. If your child's conduct was the direct result of the school's failure to implement the IEP, the school must take immediate steps to remedy those deficiencies. Your child must be returned to the placement from which they were removed unless the misconduct involves a weapon, illegal drugs, or serious bodily injury to another person. There are protections for children who have not yet been determined to be eligible for special education if the school had knowledge that the child had a disability before the behavior that resulted in disciplinary action had occurred. Educational records. This is on page 9 of the procedural safeguards document. Is there a fee? If you request copies of your child's records, the school may charge a fee for copying, as long as that fee does not keep you from being able to inspect and review the records. Consent. Your consent, or the consent of the adult child, must be obtained before education records can be released to people or organizations outside of the Texas public school system. On request to review your child's records, the school must make them available without unnecessary delay and before any ARD meeting, due process hearing, or resolution session, and no later than 45 calendar days after the date of that request. Private school placement by parents. Parents have the right to voluntarily place their child in a private school, but federal regulations do not require a public school to pay for the cost of education, including special education and related services, for a child with a disability at a private school or facility if the public school made free, appropriate public education, or FAPE, available to the child. Transfer of parental rights. All parental rights under federal regulations transfer to a child when the child reaches the age of 18 in Texas. At the age of 18, a child has the right to make their own educational decisions. The school must still provide parents with notices of ARD committee meetings and prior written notices, but they may not attend the ARD meeting unless the adult child specifically invites them to the meeting, or the adult child gives them that right in a supported decision-making agreement. On or before the student's 17th birthday, the school must provide you with written notice about the transfer of parental rights to your adult child, unless you have obtained guardianship or the student signs a valid power of attorney or a supported decision-making agreement. Resolving disagreements. This section takes us through the end of the procedural safeguards, and it goes from pages 12 to 20. There is quite a lot of information in the document. We are going to just kind of briefly discuss this section. So there may be times when you disagree with the actions taken by the school related to your child's special education and related services. Families are always strongly encouraged to work with school personnel to resolve differences when those occur. The Texas Education Agency, or TEA's, options for resolving special education disagreements. State IEP facilitation. The disagreement must relate to an ARD committee meeting where mutual agreement was not reached on at least one of the required areas of the IEP, and the ARD committee agreed to recess and reconvene. Mediation services. The goal of mediation is to assist the parent and the school in reaching agreement. Special education complaint resolution. A written complaint must describe the special education violation, facts on which the complaint is based, parent signature, and contact information. And the due process hearing program. A parent can request a due process hearing from TEA on any matter relating to the identification, evaluation, or educational placement of their child, or the provision of FAPE to their child. Some additional resources for you. These are available on the SpedTech's website. There is an overview of the Individuals with Disabilities Education Act, or IDEA. Parents' rights, an overview of special education evaluations. What is an IEP? ARD committee members, the special education complaints process, and a document on resolving issues with your child's school. SpedTech is always available to help. Our website is listed here, as well as the email and phone number. If you are not aware of SpedTech, it is the Special Education Information Center for the state of Texas. We are a free resource for families across the state about all things special education. I definitely encourage you to check out the resources that are available on the website and to take advantage of our call center or email if you do have a question. And then Partners Resource Network is next, and Jim told us about that at the beginning of the webinar today, but all of their contact information is also on the screen right now, and I believe that that is also being dropped into the chat so that you have access to that information and also the SpedTech's website in case you want to copy and paste that to have that handy. We definitely thank you for your time today. My email address and Jim's email address are both on the screen. If you have any questions about the procedural safeguards or about anything else related to special education, please feel free to reach out and we will do our best to get those questions answered for you. Following this webinar, I will send out a copy of the slide deck. But before we go today, we do want to just share some information about some other upcoming events that we have. On September 20th, SpedTech and Partners Resource Network will be hosting a statewide webinar with TEA. And we will have Kristen McGuire with us from TEA, and she's going to be doing a Q&A about some special education updates to start the new school year. And then on September 27th, we will have our next Region 10 family webinar. Jim will be presenting that for us, and it will be all about ARD meetings. So ARD meetings 101 and everything that a parent may need to know in order to participate effectively into that process. So if you have any other questions for us before we wrap up today, feel free to put those in the chat. But again, we thank you for your time today.
All right. I don't see any questions in the chat at this time. So anybody have any questions, you can either do it in the Q&A or the chat.
We'll give everyone just a couple minutes before we end the webinar, just in case anyone has anything that they'd like to put into the chat.
Thank you all very much for the time that you've given us to attend this and learn about the procedural safeguards. Sometimes that's a document that we don't like to look at, but it's very important to know where to access it, and the information in there is valuable to when we're not sure of what to do to move forward.
And you will be seeing a poll link pop up on your screen. And so we would definitely appreciate it if you will take the time to answer those questions for us before you leave today. Thank you.
You want to go ahead and end the recording?